Well, welcome to today's Litigation Quality PatentCast. I'm the examiner whisperer, Craig Thompson of Thompson Patent Law, and today I want to tell you about a very important principle called standing as it relates to patents. And this is a critical issue that's often not well understood in terms of contracts and licensing and assignments of patents. And that's why there is a role to play for patent attorneys in the assignment and licensing of patents, even when there's contracts involved. And as we'll see in this case, very importantly, employment agreements. In employment agreements these days, almost every employment agreement has an assignments clause where the employee agrees to assign all inventions during the term of employment to the employer. Now, there are a number of cases, including today's case and cases that I've dealt with in the past personally in real live litigation. I've seen this problem arise, and there's a reality about technology companies that executives need to understand, and that is at some point every engineer is going to leave the company. Some of those exits by engineers include potential trade secret information and or patentable ideas. So that's intellectual property that's leaking out of your company that could be very valuable. In this case today that we're going to talk about, SIRF technology versus the International Trade Commission and Broadcom Corporation, there was some very valuable technology that an engineer took with him when he left his employer, and that became a hot topic. This case involves GPS technology for locating satellites in the GPS system to mobile devices, handheld devices. The interesting issue, there are several issues, but I just want to focus on the standing issue. This is the real important takeaway, business valuable takeaway for company executives of technology companies. The engineer who left the company, his name was Charles Abraham, and he left Magellan Corporation. But before he left Magellan Corporation, he conceived of a patentable idea. He ended up leaving the corporation with that patentable idea and then went to another corporation, Global Locate. And Global Locate became the assignee of his patentable idea that he developed while he was employed by Magellan. So if you're the owner of a company like Magellan and you're employing an engineer like Charles Abraham, you just lost out on potential trade secrets and extremely valuable patentable protection over GPS technology. Turned out to be quite valuable. Even though there was a employment agreement clause saying he assigned all the inventions, it actually doesn't play out so cleanly. So there's a couple of points I want to bring to your attention. The first is the relevant law is the standing issue, meaning absent the voluntary joinder of all co-owners of a patent, a single co-owner acting alone will lack standing. What does that mean? If you or your entity do not own essentially all the rights to a patent, you have a co-owner, you lack standing to sue anybody or to enforce that patent unless and until you get cooperation in the lawsuit with all of the joint and co-owners. Well, why is that important? Well, if your inventor, your engineer who left your company is by default, because he's an inventor, he's automatically the first and primary owner of the patent. So what usually should happen is that the inventor should assign his or her rights to your company. But because that inventor filed the patent application after he left your employment, even though he conceived of the idea while you were still giving him a paycheck, there's a possibility, and I've seen it happen, and it did happen in this case, that the original employer who was paying the engineer while he came up with this idea is completely not an owner of this idea. And that's the story that I want to explain to you how this actually works, even though it looks like a nice, tidy, neat employment agreement with an airtight assignment of rights, assignment of inventions clause to protect the intellectual property and trade secrets. It's not necessarily the case. Convey to you what happened in this particular case. And interestingly, this was with the International Trade Commission. instead of district court. International Trade Commission is an alternative route for patent infringement lawsuits. Most patent suits are brought in federal district court. This is International Trade Commission, which in the International Trade Commission is just, by the way, interestingly, an avenue for blocking, getting an exclusion order to block importation into the United States of infringing goods. And you can't get damages. You can't get monetary damages, but it can be a lower cost, faster process, and you can get the effective exclusionary order so that I guess customs can seize product at the border or at the port as it's coming into this country. So in this case, SIRF, or I'm going to call them SIRF, among other defendants, were all determined to be infringing on all 6 of these patents in suit here relating to all this GPS technology or assisted GPS technology. But I want to focus on the business issue here about the standing, because it sounds a little bit kind of abstract, but it's actually extraordinarily practical and important for business owners. And I'm going to give you at the end here some actionable steps that you can use that I don't know of any companies that are actually doing to plug this hole and to better protect your intellectual property and your potential intellectual property. Right now, it's sitting in the heads of your engineers and your inventors. In this case, an inventor, Charles Abraham, who was later joined by a co-inventor, Donald Fuchs, was an employee of Magellan. If Magellan is a co-owner, the former employer is a co-owner on this patent, then this whole patent suit at the International Trade Commission goes away, because Magellan would not, if Magellan wasn't party to this law, to this enforcement action, then the parties Global Locate would not have standing to sue. So that would have, it's important for the CEO of Global Locate to say, okay, I've hired this guy, this engineer away. We filed this patent application. We got a patent. We go to enforce it. Turns out he might have had rights to his old company. He maybe shouldn't have assigned it to me. He maybe should have assigned it to his previous employer. Not only can they sue me for trade secret misappropriation, I just wasted money filing this patent enforcement action at the ITC, and I don't have standing. So it's important for the second employer as well to understand this issue, as well as the first owner. So who really owns this IP? Is it Magellan? Is it Global Locate, the second employer, or is it Charles Abraham, the inventor, and his co-inventor? So Abraham, as I mentioned, Abraham conceived of the subject matter of one of these patents in October of 1999 while employed at Magellan. In 1996, Abraham had entered into an employment invention agreement with Ashtec, which is a predecessor to Magellan, and that employment inventions agreement assigned to Ashtec, quote, all inventions which are, here's the key language, related to or useful in the business of the employer, and which were conceived during the period of the employee's employment, whether or not in the course of the employee's employment. Now that sounds like a great clause for a very standard, well-written, buttoned-up employment agreement, but guess what? It didn't hold water. It did not work. Let's explore why. And again, at the end, I'm going to propose a way for you to maybe plug this hole in your business if your technology is at risk and you thought you were protected by this inventions assignment clause in your employment agreement. Maybe it's not. The court here said, in the opinion, said that while the record's a bit unclear, it appears that likely that Abraham's agreement with Ashtec was assigned to the merged company, which is now Magellan. Abraham testified that at the time of the conception of the invention, while he was employed by Magellan, he was still subject to the original Ashtec agreement. So that original is not disputing that Ashtec or Magellan didn't have rights to that agreement. Abraham separated from Magellan in February 2000 and then joined Global Locate. In May 2001, he and his co-inventor applied for one of the 6 patents, and this was eventually assigned to Global Locate, the second employer. There was 2 parts to this, and one part went like this. The Federal Circuit that's reviewing this ITC decision found that the Abraham Ashtec agreement did provide for automatic assignment. So there was an assignment. The question of whether or not an agreement provides for automatic assignment is a matter of federal law. If the contract expressly grants rights in future inventions, then no further act is required once an invention comes into being, and the transfer of title occurs by operation of law. So that's good for the employer. Here, the agreement provides that the employee assigns all of his or her right, interest, or title in any invention to the employer to the extent allowed by law. By using the language, quote, employee assigns, close quote, the employee assignment agreement expressly grants with no further action needed on the part of the employee. Therefore, the provision is one of automatic assignment. So far, so good. That seems like the Magellan, the first employer, should have gotten an automatic assignment. The question remains whether the invention is, quote, related to or useful in the business of the employer within the meaning of the agreement. So this second question is a matter of state law. So was this specific invention that became the subject of the patent, was that related to or useful in the business of the employer? In oral argument, my understanding is that the Magellan was working on surveying, like land surveying technology with the GPS, and the patentable aspects that were more valuable that ended up leaking away from Magellan related to, GPS, assisted GPS, improving that for communication with mobile devices, which is a much bigger, obviously a much more lucrative deal, application of the GPS technology. Was this mobile handset idea, which Abraham came up with while he was employed with Magellan, was that related to or useful in the business of Magellan, who was at the time working on land surveying applications? That question is a matter of state law, in which case this is California law. Neither the agreement nor the California Labor Code specifies what it means for an invention to be, quote, related to or useful in the business of the employer. The terms related to and useful in are inherently ambiguous. Okay. Under California law, when a contract is ambiguous, extrinsic evidence is admissible to prove a meaning to which the contract is reasonably susceptible. So enter the lawyers. Such extrinsic evidence may include evidence of the nature of the employer's business and the nature of the employer's work for the employer. See how complex this is getting and how the legal bills are going up for the litigation here? Again, I'm going to propose an opportunity for a solution to avoid all this litigation at the end here. Such extrinsic evidence may include evidence of the nature of the employer's business and the nature of the employer's work for the employer, as well as evidence of the conduct of the parties, i.e. evidence probative of whether or not they regard the invention as falling within the agreement. There's a treatise on the law of contracts that holds that the parties' own practical interpretation of the contract, how they actually acted, thereby giving meaning to their contract during the course of performing it, can be an important aid to the court. So how the parties acted is helpful to figuring out how to interpret the contract under California law. So resorting to extrinsic evidence is necessary to determine whether the contract provision applies. And the ITC, in concluding that Global Locate did have standing, so it was in fact the owner of these patents, even though they were initially conceived while Abraham was working for Magellan. Global Locate has standing and is the true assignee of these patents because there was no evidence that the invention of the patent was related to or useful in the business of Magellan. In reaching this conclusion, the ITC pointed out that none of the evidence to which appellants have cited relates the specific invention of the patent to any particular aspects of Magellan's business. The commission also relied on the fact that in light of Magellan's awareness of the invention of the patent and its failure to assert ownership of the invention at any time, Magellan itself did not consider the invention related to or useful in its business within the meaning of the employee invention agreement. So even though they had that nice sounding, bulletproof sounding invention assignment clause, and the invention was conceived by the engineer while being paid by Magellan, Magellan got Zippo. Federal Circuit on appeal here concluded that the ITC properly found that the burden of proving standing rests with the people challenging the standing. Now, there's a process by which patents are, when they're assigned, they're also should be recorded. That's the best practice. And you record a patent assignment at the patent office, just like you would record a deed at your courthouse, you know, if we're talking about real property. The recording of an assignment with the patent office is not a determination as to the assignment itself is valid. However, it does create a presumption of validity as to the assignment. So if you're going to say once Global Locate recorded that assignment, now anybody challenging that assignment has a burden of proof. See how complex this is getting and more legal fees? That would be nice to avoid if we could. Wouldn't it be great if we could avoid all this litigation and all these questions by being proactive and doing something much less expensive and much less painful than all this a very risky litigation that they ended up losing anyway? By the way, owning the IP outright without anybody questioning it. The statutes provide that recordation of an assignment with the PTO can be the basis for a bona fide purchaser defense. Okay, I'll spare you the legal jargon here. It's important to get patents assigned and recorded so that the company clearly owns them, so the company can do what it needs to do. Doing it sooner rather than later is good. I'll just simplify it down to that. Normally, when we file a patent application, we record the assignment within days of getting the... Because the phrase related to or useful in is inherently ambiguous, now talking about the invention assignment, that nice bulletproof language that actually didn't protect Magellan. Because the phrase related to or useful in is inherently ambiguous, the court said, the commission, the ITC commission, was correct in looking into the party's own interpretation of this language as being determinative. Here, there is evidence that the parties indeed interpreted the agreement in a way that is fatal to the appellant's interpretation, meaning Magellan didn't own it, Global Locate did, and so Global Locate can proceed with enforcing its patent. In June of 2000, Magellan sued Global Locate as well as Abraham personally, the inventor, for trade secret misappropriation. See, there's another lawsuit involved here. So it started with the trade secret misappropriation, and now we're in the ITC and a patent enforcement action. See, all this could have been avoided with a little bit of proactive action. At the time of the litigation, Abraham had already commenced working for Global Locate and apparently had assigned his rights to the invention to Global Locate. The litigation was concluded by settlement in March of 2001. At the time of the settlement, the application for the patent had not been filed, and the rights to the patent were not directly involved in the trade secret action. Abraham's agreement with Magellan or Ashtec covered not only patented inventions, but also inventions that were not patented, including inventions represented by trade secrets that were related to or useful in the business of the employer. During the litigation, Magellan was provided with documents prepared by Abraham while at Magellan relating to the conception of the subject matter of the patent. As part of the settlement agreement, although there was no compensation flowing from Magellan to Global Locate, Magellan and Abraham appeared to recognize that Global Locate was the owner of the invention in question, stating that nothing in this agreement shall preclude Global Locate from using any of the following technical concepts, and then ... 6, shortening the signal shift register with the number of bits being divisible by 1023, close quote. The parties agree that this is the technology involved in the asserted claims of the patent. If Magellan and Abraham recognized that Global Locate was the owner of the trade secret rights to the invention, it logically follows that Magellan and Abraham did not think Magellan was the owner of similar rights that eventually became the subject of the patent. Further, following the settlement, Magellan informed one of its customers that after, quote, a diligent examination of information produced during discovery, close quote, there was no evidence of trade secret misappropriation by Global Locate and Abraham. So during the settlement, they apparently did a release, a public release, a press release to the customers, clearing the cloud over Global Locate, part of the saying that there was no trade secret misappropriation. If Magellan had owned the invention, the disclosure of its trade secrets by Abraham to Global Locate would have been misappropriation, but they publicly said it wasn't. So it is therefore reasonable to conclude that during the trade secret litigation, Magellan determined that it was not the owner of the invention. that is not uncommon set of facts because, again, every inventor or every engineer is at some point going to leave the company sooner or later, one way or another. Oftentimes they go to work for either a competitor or start up their own entrepreneurial shop. And oftentimes they do so with ideas that were cooked up during their previous employment. So I'm going to offer that this is something that you want to address in your business. You don't want some of your best potential, most potentially valuable IP walking out the front door of your business in the heads of your current employees who you're paying a salary to and who are developing things kind of and holding them back. I invite you to give me a call at 512-649-1046. That's 512-649-1046, and schedule a complimentary consultation. And we talk about your situation, and we have a number of solutions that we can offer to help plug that hole and handle that while creating value that's in the IP, including trade secrets and potentially patents, as well as avoiding expensive and unnecessary and frankly avoidable litigation. This story about Abraham, Global Locate, and Magellan should be instructive as to how this can easily happen in pretty much any technology business. And it doesn't have to happen to you with some simple proactive steps and some due diligence that is far less expensive and intrusive and frankly less painful and more fun to create value and avoid the legal fees that are associated with multiple litigations. I've been involved in settling litigations in a similar situation where an engineer left a company and the trade secret misappropriation filed, and we had to try to settle that, and we were successful, but it cost both sides. And it really wasn't necessary with proper communication and a few simple steps that, to my knowledge, nobody's doing right now. So let me offer that as a opportunity to help you get by next quarter. You could have your business in a place where it doesn't have as much risk exposure to great, valuable ideas walking out the door and then finding the hidden flaw in your invention assignment clause in your supposedly bulletproof employment agreement. Hopefully that's been useful and valuable to you. This is Craig Thompson, the Examiner Whisperer, and I look forward to speaking with you soon. Have a profitable day.